Bachman?
Me?
Yes, good.
Okay.
And Attorney Aiello?
Yes, I can hear you. Can you hear me?
Yes, great.
Great.
Okay. Thank you for your patience. I apologize for the technological difficulties. We did a lot better in the middle of COVID, but I don't think any of us would wish that to be back. So we're set. Thank you. All right. This is a remote hearing of the appeal Bennett v. Commissioner 45032. Your judges are Prescott, Elgo, and Alvord. Please remember, as it is remote, to hit the mute button when you're not speaking. Stay on camera at all times. If by chance you get bumped off, do not panic. We will not continue the hearing until you get back on, and Attorney Keene will let you give you assistance if you're having trouble getting back on. I have all digits crossed, hoping that doesn't happen. Both sides have 20 minutes, so we will start with Attorney Bachman for the petitioner appellant, and if you would like rebuttal time, please let me know. I'll be keeping track of the time on my iPhone.
Yes, I would
Attorney
like.
Bachman?
Yes, I would like 3 minutes of rebuttal time.
3 minutes of rebuttal, so we'll give you 17 minutes. Primary argument.
Thank you. Are we ready to go?
Yes, we are.
Okay. May it please the court. This case turns on the legal import of Attorney Cretella's, the trial attorney's, failure to inform Adrian Bennett that by pleading guilty in his murder trial, he waived his right to appeal what I'll call for shorthand the Finnan issue. The Finnan issue revolved around the identification of Mr. Bennett, purported identification of Mr. Bennett by a police officer off of surveillance video. And the law controlling that at the time was State versus Finnan. As to the extent of the duty that Attorney Cretella had to inform Mr. Bennett of his appeal rights, that is defined and applied in Roe versus Flores Ortega U.S. Supreme Court case and Gant versus Commissioner, a Connecticut Supreme Court case, and in State versus Turner, which helps define the extent of the duty established in Roe and Gant. State versus Turner is at 267, Connecticut 414. And in that case, our Supreme Court applied the duty that was identified in Roe and Gant, which is a duty to inform a defendant at any time that the attorney would reasonably believe that a reasonable defendant would want to appeal his case, that he or she is waiving their appeal rights by pleading guilty. In Turner, our Supreme Court applied that duty to a situation in which the defendant argued he should have been told of his appeal rights before entering a plea. Roe and Gant were both situations where the plea was already entered and it was a question of appeal rights from a plea already accepted by the court. This case deals with Mr. Bennett's decision in the middle of trial to plead guilty, and the plea came immediately after the police officer identified Mr. Bennett, purported to identify Mr. Bennett on the videotape, and that was over Mr. Bennett's attorney's objection.
Attorney Bachman, did
Yes.
not the appellate the habeas court conclude factually that your client still would have pled guilty even if he had been aware of his appellate rights?
Yes, but I think that conclusion by the court is inextricable from its conclusion that the appeal was frivolous, and that was a legally wrong conclusion. And his decision to the habeas court's finding was not, at least by my reading, it was not based on the demeanor and the attitude, etc., of the defendant, which of the witness, which are the things that make credibility findings so unassailable, but rather it was tied up with the idea that the appeal of the Finnan issue would have been useless. And we know from Gore and from the case law and authorities that Gore cited at the and that were in place at the time of Finnan, and more importantly at the time of this case, we know that the appeal in Mr. Bennett's case would not have been frivolous. It was based, the decision that he was appealing was based on the fact opinion distinction. The court found that, unlike in Finnan, where the police officers were giving an opinion by way of identification, in this case it was a fact. And in the Gore case, our Supreme Court held that the fact opinion distinction was illusory. And it didn't just become illusory when the Gore court discovered it. It had been illusory, and the Gore court marshaled quite a few legal authorities talking about the illusoriness of the fact opinion distinction. And that's something that Attorney Cretella should have known and should have taken into consideration in deciding whether to inform Mr. Bennett of his appeal rights, and that that would have made a difference in whether Mr. Bennett had decided to appeal and decided that he wanted to continue with the trial, to keep that appeal in play. It's one thing to keep that appeal in play when you don't have any reason for hope that it's going to succeed. It's another thing when you've got an appeal that's based on something that the Supreme Court later found was illusory, and that we should have known was illusory.
So, Attorney Bachman, are you suggesting that we read out of the memorandum of decision the paragraph at the bottom of page 22 and at the top of page 23 where the court squarely addresses and the prejudice prong and credibility?
I'm just checking on 22 and 23. Well, I'm not asking you to read that out, but I think it needs to be read in the context of whether the court made a plain error in finding that Mr. Bennett would have decided otherwise, that
He would have decided to go to trial with 197-year exposure. That's your position?
he ended up pleading guilty with 197-year exposure. There wouldn't have been any difference. So yes, that's my position.
Well, I mean, it seems a little too clever to say there wouldn't have been a difference. I mean, the sentencing, if he's convicted after completing the trial and a jury convicts him, a sentencing judge may very well look differently at that scenario than someone who at least has taken responsibility for his actions and has not put through the state and the witnesses and the other an entire trial.
That's true, but this was a situation where the judge had previously put 60 years on the case, and both Attorney McMahon, the attorney who handled the motion to withdraw Mr. Bennett's plea, and the expert attorney presented by the petitioner agreed that 60 years was basically a floor. I mean, that he wasn't going to get less than that, and that's a life sentence. So,
right, Attorney Bachman, it seems to me that the habeas court's made a factual finding that your client would still have pled guilty. Okay, that's subject to a well-known test that there basically has to be no evidence in the record to support the finding, or that the court is left with a definite and firm conviction that a mistake has been made.
yes.
And it seems to me the habeas court relied upon a number of factors in assessing your client's credibility, including his in-court testimony, that he still would have pled guilty. I'm just at a loss as to how are you arguing that we should just conclude that we should be left with a definite and firm conviction that a mistake has been made?
Yeah.
Because there's certainly evidence in the record to support it.
Yeah, no, I'm relying on the mistake has been made prong.
Okay.
And the reason that the mistake has been made, and the reason that I'm arguing that you should feel that a mistake has been made, is because of the court's mistaken assessment of the appeal possibilities that were available to Mr. Bennett.
Just by the way, Finan, as you know, has now been overruled and replaced by a different test. Does that have any bearing on the issues in this habeas appeal?
Well, I think it does. I mean, the Finan or Finan, as I've been calling it, is clearly the controlling law in this case, but we don't have to blind ourselves to the vulnerabilities of Finan that were pointed out by the Gore Court. And the fact that the Gore Court finds that the fact-opinion distinction on which this case turned below, was illusory. And that was true at the time of Finan, and it was true at the time of this case. And the Gore Court's analysis enables us to see that clearly, and we don't need to ignore that accordingly. And under Strickland and the deficient performance prong, the question is whether a reasonable defendant in Adrian Bennett's place would have wanted to know his appeal rights, and if an appeal would be non-frivolous, the answer is yes. And Turner defined.
But Attorney Bachman, but what you're essentially arguing is that in any instance in which an appeal potentially would have some merit, a court is essentially obligated to disregard the other factors that it might consider in deciding whether or not the defendant still would have pled guilty.
I don't think that I'm arguing that. I think I'm arguing in the specifics of this, the specific situation of this case, where there was a very vulnerable controlling law that the attorney had a duty, constitutional duty under Flores-Ortega and Gant to inform Mr. Bennett of his appeal rights, and that had he done so, the analysis of whether Mr. Bennett would have continued with trial or not would necessarily be different. It's not simply that it's an non-frivolous appeal issue, but it's that it's the nature of it in this particular context where the entire case really turned on really turned on the fact opinion distinction that would have been appealed. I do just want to note quickly in the last minute that I have, Attorney McMahon, who we are alleging was ineffective, constitutionally ineffective for failing to raise Attorney Critella's failure to advise Adrian Bennett regarding the appeal rights, is that he failed to do that even though he purported to believe that those rights are the most important rights one waives when pleading guilty, and his explanation that it was not an objectively proven claim makes little sense. I don't know what he means by it, if the claims that he pursued were somehow objectively proven, but this claim.
Okay, you're out of your primary time. You do have 3 minutes rebuttal, Attorney Bachman. Attorney
Okay.
Aiello.
Thank you.
Good morning, Your Honors. May it please the court, my name is Brett Aiello. I'm an assistant state's attorney. I represent the Commissioner of Correction in this matter. As Your Honors touched on in the petitioner's primary argument, the judgment can be affirmed on the basis of the habeas court's unassailable credibility determination regarding the petitioner's claim of prejudice. The habeas court stated that it did not find credible the petitioner's habeas testimony that he would not have pleaded guilty had Critella advised him about appealing the denied motion to eliminate after trial and sentencing. Now, that credibility determination is well supported by both the record and relevant case law. In terms of the latter, Your Honors, this court, as well as federal courts, have talked about, have discussed in evaluating these claims of prejudice in the Hill-Strickland context, have discussed that the strength of the state's case is often the best evidence of whether a defendant would have changed his plea, would have insisted on going to trial, Caraway, for example, which this court decided, and which is cited in the habeas court's memorandum decision, stated that the prospect of an acquittal or a more favorable sentence after trial is clearly relevant in considering whether counsel's advice with respect to a plea offer would have changed had he not performed efficiently. Indeed, it may be the single most important consideration. Now, how is that relevant here? Well, there's a couple factors. The strength of the state's case may not be dispositive here, but it's squarely relevant to the petitioner's prejudice claim. I don't think there's any dispute, number one, that the state's case was strong, that the surveillance video in conjunction with the detective's identification of the defendant on that video, which was the crux of the Finan issue, that was powerful evidence. It's not a coincidence that the petitioner pled guilty at that time. The detective hadn't even concluded direct examination before the petitioner had pled guilty. So in conjunction with that, number two, it was clear that the petitioner wanted to avoid a surefire conviction after trial and the extended exposure that came with it. The habeas court to that effect stated the evidence shows that Bennett was concerned with receiving as low a sentence as possible, and an open plea in front of Judge Clifford was the mechanism he chose to effectuate that desire. So this was based.
Attorney
Yes.
Aiello, can I interrupt for a second?
Yes.
What in putting on the testimony in which I believe it was a detective that identified him on the
Correct.
on the video, did the state introduce facts that would suggest that he was in a better position than the jury to identify the defendant from the video than the jury would be? In other words, did he have past familiarity with the defendant? The types of things that Gore and Bruni kind of now ask us to look at.
He did. He did have that general familiarity with the defendant, which would have put him in a better position than the jury to identify him as the perpetrator of the crimes. The state did inquire as to that familiarity, and Detective Potsie had testified that he, on his beat as an officer, he would routinely encounter the defendant, and I think he may have even said 5 days a week he would walk by a particular hangout where the defendant was, and so had an opportunity to view his voice, his mannerisms, his general appearance. So there was his exposure to him on his walking beat, and there was exposure to him during a police interview in connection with a separate case where Potsie had an opportunity to view the defendant. So it was based on that familiarity, which certainly put him in a better spot to view to identify the defendant, and that's consistent with the Finan, Felder, and Hawley line of cases, which Gore obviously has overruled Finan, but at the time it was the level of familiarity with the defendant was the key analysis in terms of whether that testimony was opinion or fact. So under the prevailing law at the time, and I would argue that even under Gore, that testimony would have been admitted.
What was the nature of the quality of the video?
Well, Judge Fisher made a factual finding during his ruling that it was a high quality video. That's a bit of a subjective statement. I've had the opportunity to view the video. There's certainly a number of different angles. I don't, and it's hard to put yourself back, at the time of trial and comparing the appearance of the defendant to the appearance of the perpetrator of the crimes. I don't know that it was so high quality that testimony to Potsie's effect of identifying him was completely unnecessary. I think it was certainly helpful to the jury in identifying him as a perpetrator. But Judge Fisher did make a finding that it was, quote, high quality video.
Do you think that it is more or less difficult for the state to introduce testimony of this sort after Gore and Bruni overruled Finan? Do you understand what I'm asking?
I do. And I'm not sure. I don't think the landscape has changed. My reading of Gore, and there's 4 factors that the court looks at in analyzing whether this evidence is admissible, and I think there's a heavy emphasis on, the number one. The first factor is the witness's general level of familiarity with the defendant's appearance. The court in Gore said a witness's general familiarity with the defendant is relevant both to whether the testimony is rationally based on the witness's perception and whether the testimony is helpful to the fact finder. The court went into a number of examples of other cases where admissibility was favored, and there were circumstances that were less impactful than the ones in this case, where, for instance, in a Sixth Circuit case, the trial court properly allowed video surveillance identification testimony of a federal agent who observed defendant in drive-bys of the defendant's farm. So it was, he was viewed at a distance. So ultimately, I think the level of familiarity, which is consistent with the Finan Felder line of cases, I think that factor is still in place and still highly relevant. So I don't know overall whether it's more difficult, but I can say in this case, I don't think it would have mattered what case was being analyzed. So ultimately, there's coming back to the prejudice, there's a number of factors in this case that I go into more in depth in my brief, but that the habeas court found in terms of the petitioner wanting to plead guilty at that moment. Cretella testified to it as well. This was about trying to salvage something. There were various notes passed back and forth with the petitioner asking Cretella, can you get me 30 years? Can you get me 20 years with 10 special parole? And eventually Cretella writing him that he thought the best he can do was a open plea, no recommendation. So the habeas court reasonably discredited the petitioner's claim because these factual findings were just frankly at odds with the petitioner's claim of prejudice here. That if he only knew he could appeal Judge Fisher's ruling on the Finan issue, that he would have continued on. That, as the habeas court found, presupposes a conviction, which the petitioner wanted to avoid. And that was, I would just note the crux of the petitioner's claim at the motion withdrawal hearing was that one of the claims was that he believed that Cretella was going to procure him a deal between 20 to 25 years of manslaughter, which Judge Clifford discredited. So I think the habeas court could have also considered that as that's really the frame of mind the petitioner was in, was trying to get as low a deal as possible. And so the fact that he may have been able to appeal one issue, the habeas court reasonably found just was not credible. And I would just note, the petitioner mentioned, that finding is inextricable from a conclusion the habeas court made that an appeal would have been frivolous. The habeas court never said it would have been frivolous. I think there's clearly a difference between a frivolous claim and one that's without merit. The habeas court said Finan would not provide a basis to grant Bennett a new trial based on a challenge to the denied motion in limine. It went into an analysis of that case in relation to the facts of this case. There's a clear difference between a non-frivolous claim and a claim that would be without merit. Now, I believe the Finan issue would have been without merit on appeal. I don't think it would have been frivolous to raise it. So I just wanted to make note of that. And in terms of Attorney Cretella's or Attorney McMahon's performance, I'll defer to my brief on that unless this court has any questions. But But ultimately, as it was touched upon, this court can affirm the habeas court's judgment on the basis of its credibility determination that that it did not believe the petitioner's claim that he would have continued with trial had Attorney Gratella informed him he could appeal the fine and issue. So unless
Counsel, how old was the petitioner at the time of trial?
I believe he was around 25 years old, Your Honor. I don't know that exactly.
It seems to me if he's 45 and looking at a 60-year sentence at a minimum, he's more likely to roll the dice than if he's in his early 20s and there's some possibility he could end up serving the 60 years and eventually be released.
I think that's generally true, Your Honor. I think that would have potentially changed how, changed Gratella's advice with respect to that matter. He mentioned he had talked about with the petitioner about, the petitioner wanting to own a McDonald's one day, and that this plea would at least give him a shot to do that. But if he's 45 and we're looking at 60 years, there's no testimony or evidence at the habeas trial about life expectation of incarcerated individuals. But certainly I think generally the advice probably would have been different if he's 45 looking at 60. Certainly. And unless there are any further questions, Your Honors.
I see no further questions, Attorney Aiello. Thank you. Okay,
Thank you, Your
Attorney
Honors.
Bachman, you have 3 minutes remaining.
Thank you. I think he was 31 years old, as I remember the record. So he was sort of in between the 25 and the 40. If the appeal issue wouldn't be frivolous, as the commissioner admits, that created a duty in Gratella to inform Mr. Bennett of his appeal rights under Turner. And I would urge that. If the strength of the state's case is the best measure of what a defendant would do with respect to pleading, certainly it's true that the strength of the appeal would have something to do with his decision to forego such an appeal. And the difference between an appeal that has no merit and that deals directly with something that the Supreme Court called illusory should give us pause. And finally, in terms of the court's question regarding the quality of the tape, Judge Fisher made found a couple of times that it was a very high quality tape. And I think, given the amount of time that the shooter is on the tape, there's no reason to think that the jury couldn't have made its finding as well as without Detective Pasiad's testimony. And unless there are any questions, I'll leave it on the brief.
Thank you. I see no additional questions. Thank you, Attorney Aiello and Attorney Bachman, and thank you for being so patient this morning.
Sure thing, Your Honor. Thank you.
Bye-bye.
Bye-bye.